going to be answering our second set of questions. So turning to question number 1 first. The fact pattern says, 3 women were charged with armed robbery of a liquor store. 2 of the 3 women met together with an attorney. The 2 women asked the attorney to represent them in the criminal matter. The attorney decided to talk to each woman alone prior to agreeing to represent them jointly. The attorney was told by both women individually that the 3rd woman was the guilty party. Both women explained to the attorney that the 3rd woman said she needed to grab something to drink from the liquor store, and that she robbed the cashier while they waited outside. Both women stated that they had no idea that the woman intended to rob the liquor store. After interviewing each woman separately, the attorney agreed to represent both jointly. Shortly before trial, one of the women that the attorney represented decided that she wanted to take a plea deal offered by the prosecution and testify against both of the other women. It is proper for the attorney to do which of the following? So we're getting in the habit of asking ourselves, what rule is this question testing? Here, based on these facts, this question is testing whether or not this attorney can get around this current client conflict. So why is this a current client conflict? Because we're told that this attorney has agreed to this joint representation. But unfortunately, one of the parties has decided to take a plea deal and now as a result has to testify their previous, co-party. So what is this attorney to do? Well, unfortunately, in a scenario like this is not the type of current client conflict that this attorney can get around. This is one of the dangers of joint representation. I call it a danger because in a scenario like this, what the attorney is forced to do is to withdraw from representing both women. The man has too much information, and having previously represented both of them, or currently representing both of them, based on these facts, the man can now not just represent one of them. That is not okay. This is not like a consentable conflict of interest. So basically, we'd be looking for an answer choice that says it's proper for this attorney to withdraw from the representation of both women. So let's turn to our answer choices to see if we see something like that. Answer choice A says it's proper for the attorney to do which of the following. A says to ask the court for permission to withdraw from representing both women because the interests of the women are directly adverse to one another. Okay, so this looks pretty good. This illustrates and embodies the fact that this lawyer needs to withdraw from both. So let's hold on to that, but let's assess the other answer choices. Answer choice B says, get permission to withdraw from the court as the attorney for the woman who wants to take the plea deal and continue to represent the woman who does not want the plea deal, after getting the woman who wants the plea deal to consent to the attorney withdrawing. The attorney will also need to get informed consent in writing from the woman who does not want the plea deal in order to continue representation. Whoa, there's a lot going on in this answer choice, but we can quickly ascertain that it's incorrect because the correct course of conduct for this attorney is to withdraw from representing both parties, not to continue representing one over the other. So B is incorrect. Answer choice C says, get permission to withdraw from the court as the attorney for the woman who does not want to take the plea deal and to continue to represent the woman who wants the plea deal after getting the woman who does not want the plea deal to consent to the attorney withdrawing. The attorney will also need to get informed consent in writing from the woman who wants the plea deal in order to continue representation. Well, C is also incorrect for all the reasons B was incorrect, but I want to give everyone a little tip here. When you see answer choices like B and C, they're usually both wrong. Usually they're just kind of flip-flopping a fact and giving you the exact opposite outcome as the previous one. So again, not that you should ever deal with absolutes. You should always try to assess the question based upon the rule that it's testing, but B and C are both incorrect here. Answer choice D says, continue to represent both women after they give informed consent in writing. And D is incorrect because this lawyer has a direct conflict with these 2 women and therefore has to withdraw from representing both of them, making A the correct answer choice. Moving on to question 2. 2 says, an attorney represented a man in a breach of contract claim against the man's former employer. The attorney was able to obtain a settlement for the man without having to file suit. The employer paid the man in a lump sum, and the man paid the attorney his fee. The attorney did not do any other work for this man. About 6 months after the settlement with the employer, an attorney who represented the man's ex-wife called the attorney to inquire about the previous settlement, as the man was behind on child support. The attorney did not disclose any information to the ex-wife's attorney and instead called his client to explain the situation. The client told the attorney not to provide any information to his ex-wife's attorney. Is it proper for the attorney to furnish the information to the ex-wife's attorney? So here, what rule is this question testing? This question is testing confidentiality. I landed on confidentiality because this attorney is being asked to divulge information regarding the representation of a client, specifically the amount of money that was attached to this type of settlement. So when it comes to the duty of confidentiality, the rule says that a lawyer shall not divulge information that falls under this umbrella of confidentiality unless he gets the client's consent, or unless he's impliedly authorized, or unless an exception to the rule exists. Here, based on the facts, we know that this lawyer does not have the client's consent. The client says, do not give this information up. So that's off the table. But what does implied authorization mean? Implied authorization occurs in two scenarios. The rules state that we are impliedly authorized to share confidential information regarding our clients with other lawyers in our firm. Here, that's not what's happening. This lawyer is not sharing information with another lawyer from his firm. The second scenario in which we're impliedly authorized to disclose confidential information regarding our clients and their representation is if it's necessary to carry out the client's representation. And here we can quickly say that that's also not applicable because this lawyer is no longer representing the client. Therefore, disclosing this information is not necessary to resolve or to move forward in this litigation because it's already over. So that means the only way this lawyer can disclose this information is if one of the 6 exceptions to confidentiality exists here. And there are 6, which is helpful to have this rule memorized. So to go over those 6 exceptions to see if they're applicable. The first is that a lawyer may disclose this information to prevent death or reasonably certain substantial bodily harm. That's not what's going on here. The second scenario or exception in which a lawyer can disclose confidential information is to make sure that they're in compliance with their ethical obligations. That's again not happening here. The third exception is that a lawyer can disclose this information to defend themselves against some sort of issue that they're, say, having with a client regarding a representation with a client. And again, that's not happening here. The fourth exception is that a lawyer can disclose this information pursuant to a court order. Again, that's not applicable. The fifth exception is that a lawyer can disclose information to detect conflicts of interest. Again, that's not what's happening. There's no law firms merging here or anything like that. And the final exception is that a lawyer can disclose confidential information if the client has used the lawyer's services in furtherance of committing some sort of crime or fraud. And here, I know a lot of people might think that that looks enticing as maybe an applicable exception, but it is not, because we do not have any facts here that illustrate that this client has used the lawyer's services to commit a crime or fraud. In fact, the client is no longer using the lawyer's services at all. His matter has settled. This is something, this back due child support, that has arisen after the fact, and the lawyer is not being used as an instrument in any way. So that leads me to believe that there is no way in which this lawyer can disclose this information. So let's try to find the correct answer here based on the choices provided. So the call to question says, it is proper for the attorney to furnish the information to the ex-wife's attorney. A says yes, because the attorney may reasonably believe that disclosing this information would prevent the client from committing a crime. A is wrong for all the reasons we already talked about. While there's technically the crime fraud exception to confidentiality, the client is not using the lawyer's services to do so. So A is wrong. B says yes, because disclosure is necessary to carry out the representation of the client. B is wrong because, as we discussed, the representation of the client is over. C says no, because the client told the attorney not to provide this information. So C looks good. C is factually accurate. C is also logical reasoning here based on the rule. So let's hold on to C. D says no, because the attorney did not reasonably believe that disclosure of this information would prevent reasonably certain death or substantial bodily harm. D is incorrect because that's not the only reason or set of circumstances in which a lawyer could disclose this information. So D is just wrong, making C the correct answer here. Question 3. An attorney was representing a plaintiff, a popular musician, against a famous actor in a divorce action. Since both the plaintiff and defendant were famous, the lawsuit received a lot of publicity. The attorney and the plaintiff had reached an agreed-upon hourly rate at the beginning of representation, and the attorney was billing the plaintiff throughout the case. Recently, during a conversation between plaintiff and the plaintiff explained that she was running out of money paying the attorney. Plaintiff offered to give attorney the media rights to any and all books, movies, or television programs based on the litigation as payment for representation. The attorney responded by telling the plaintiff to consult a different attorney to make sure the offer was in her best interests and that they could discuss the arrangement in a couple of days. The plaintiff sought independent legal advice on the issue and assigned all media rights to the attorney a few weeks later. The attorney had the plaintiff give informed consent in writing upon agreement to assign attorney the media rights. Is the attorney subject to discipline if he agrees to plaintiff's offer? So here, the rule that this question is testing is whether or not a lawyer can obtain media rights to basically the context or anything related to the representation of a client. And the rules here tell us that a lawyer cannot do this or enter into or negotiate this type of agreement while the representation is ongoing. So here, based on the facts, we know that that's problematic because the lawyer is basically being asked to enter into this type of agreement and the divorce has not yet settled. So I guess the quick answer to this question is that the attorney will be subject to discipline if the attorney enters into this agreement because the matter has not yet finalized and is still ongoing. So let's turn to our answer choices. A says yes because the fee structure would likely give attorney a fee that's not reasonable. That's basically wrong reasoning here. Obviously, the reasonableness of a fee is important, but that's not necessarily what's wrong with this agreement, at least not the glaring issue. The glaring issue is that this was agreed upon or being negotiated during the representation. So A is wrong. B says yes because the attorney is still repping the plaintiff and as the matter is still ongoing. So B looks really good. B is everything we just said. So let's hold on to B. C says no because the client gave informed consent in writing to the agreement. C is wrong because it misses the point that is being tested here, that you cannot enter into this type of agreement while the matter is still ongoing. And D says no because the attorney told the plaintiff to seek independent legal advice and then waited a couple of days before entering into the agreement. Again, D is incorrect because that is not what is required here. What the rule says is you cannot enter into this type of agreement while you are still representing the client, which makes B the correct answer.